Hello, everyone. My name is Nevin Akaydın. I am a librarian at Santa Clara City Library. Welcome to our webinar, Landlord and Tenant Laws in California. Today, I am with Allysson McDonald from Project Sentinel. Thank you, Allysson, for your time and being with us today.
Thank you very much for hosting. This is wonderful opportunity for us to share information that's so important for both tenants and landlords. The presentation is about tenant protection, so it kind of skews towards tenants, but the information will be very helpful for landlords who are trying to figure out what they can and can't do as well. So as I mentioned, I'm with Project Sentinel. The Law Foundation of Silicon Valley partnered with us to do a presentation on tenant protections for Catholic Charities staff back in July. And a lot of the information that I've included in this presentation was generated by them. So I want to give them credit for helping us out with that. As I said, my name is Allysson McDonald, and my phone number is area code 408-856-9079. And I'll share that information at the end of the presentation as well. We're a nonprofit organization. We've been around for about half a century. And we strive to achieve equality and fairness in housing opportunities. We are the largest agency in Northern California approved and funded by the Department of HUD. And we serve 33 local jurisdictions, as well as partnering with state and federal agencies. And our mission is to develop and promote fairness and equality of housing opportunity for all persons, and to advocate peaceful resolution of disputes for community welfare and harmony. So we have three major programs. One is tenant landlord dispute resolution, and that's the one that I'm associated with. We also have a fair housing department. They deal with questions about discrimination in housing, and also helping people who need accommodations to access accommodations. And then we have another division that helps first-time home buyers or people with mortgages who need to negotiate with their creditors. So I'm going to start with a recap of the pandemic eviction protections. As you know, things were changing rapidly starting in March of 2020 through August 31st of 2020. Tenants were protected from non-payment of evictions if they submitted a declaration of COVID-19 financial distress. But as the pandemic started to drag on, the rules changed, and between September 1st, 2020 and September 30th of last year, tenants were protected for non-payment evictions if they submitted a declaration and paid at least 25% of the rent that they owed. And then starting October 1st last year, until June 30th of this year, landlords were prohibited from getting a summons, an unlawful detainer or eviction summons for non-payment if the tenant had a pending application for rental assistance that they filed by the deadline of March 31st, 2022. So those protections came to an end June 30th. And there are no existing pandemic protections in this county for non-payment of rent that came due after the end of March of this year. There are some ongoing protections for non-payment, however. Tenants who still have a pending application with the state COVID-19 rent relief program are protected from judgment in certain cases if they filed before July 1st, but not all cases, and that's complicated. I said that you should contact our office to see if you're protected, but I would actually probably refer you to the Law Foundation if you aren't sure. And another protection from eviction for non-payment is a law that helps tenants whose ERAP applications were ultimately approved. The court can reinstate the tenancy if the complaint is based on rental debt accumulated because of COVID-19 hardship and the tenant applied for rental assistance and was approved for the full amount asked for in the notice. the application has to be made before a lockout. So it's important to get legal advice about that one as well. And that's very limited cases at this point because the deadline for application was March 31st. Under Health and Safety Code 50897.3E2, landlords are required to verify that they have not received rental assistance from any source and they don't have a pending application for rental assistance for the rent that the tenant is being evicted for. And it protects tenants with those pending ERAP applications for rent that was due before April of this year. It's not widely known that this subsection of the Act didn't expire. So tenants may need to educate their landlords about this. You can call us if you want us to talk to your landlord, or you can contact the Law Foundation, Bay Area Legal Aid, or another attorney for more specific advice. I meant to say at the beginning, we don't provide legal advice. We do landlord-tenant dispute resolution. We can educate people about their rights and responsibilities, but we don't provide legal advice for specific situations and would refer you to an attorney in those cases. Tenant groups filed a lawsuit against HCD, that's Housing and Community Development, the department of the state that was running the California COVID-19 rent relief program. And they did so because they felt that the department failed to provide due process, failed to provide language access in different languages. There was disparate impact, so they felt that was discriminatory. They failed to affirmatively further fair housing and failed to provide public records. That was the basis of the lawsuit. And the outcome was a court order on July 7, 2022, that granted the petitioner's request for a preliminary injunction. They ordered Housing and Community Development to stop denying rental assistance and stop the clock on initial denials of assistance and denials of appeals. So what does that mean? It means that they cannot issue any denials of rental assistance to applicants who timely submitted their applications. That means by March 31st at midnight, and are awaiting an initial determination. So those who submitted by March 31st, but have not gotten a determination of eligibility of approval. And they're also prevented from denying any pending appeals. They can't issue a final decision denying an ERAP application if the tenant did not submit an appeal after 30 days. That applies only to a certain time window. So let me give you more detail on that. The order does not stop them from continuing to review applications that were in the system and doesn't stop them from approving them or for asking applicants for additional missing information. So if you still have an application pending, be sure you're watching for letters, emails, task assignments coming from either Neighborly Software or Housing is Key or the Department of Housing and Community Development. They said at that time there were 100,000 households that would be impacted, including people who had not had an initial decision yet, and those who had been denied between June 7th and July 7th. That's that window I was talking about, or people who had an appeal that had not been decided yet. Tenants who received a final denial of their application before June 7th are not covered by the court order and their applications will remain denied. That's unfortunate news, but something that we have to share with people who have that situation. So again, I want to remind you that for April of 2022 through the current time, for non-payment evictions, tenants who are being evicted don't have any COVID-19 related legal protections. They should seek help from local rental assistance programs, and a good place to start is the Santa Clara County Homeless Prevention System. You can call 408-926-8885 or email them at info@preventhomelessness.org to find out if you're eligible for assistance. They may refer you to a local partner agency that will do your assessment. And unfortunately, a lot of them are really impacted right now. So if you think you're going to need financial assistance, you need to start that process right away because it might take a while. There is money available, from my understanding, especially in certain cities, but the agencies that are administering the program have very little bandwidth right now to handle new cases. But it's important that you seek financial assistance if you can't pay your rent. And if you get an unlawful detainer summons, you need to respond. So there's several ways you can do that. The Law Foundation has a phone number you can call, their intake line, 408-280-2424, Monday through Friday from 9 till noon. And then they have walk-in hours at their office on Tuesdays and Thursdays from 1 to 4. And Bay Area Legal Aid can also be another source of legal advice at 408-850-7066. I'm going to give you some more information about evictions and court cases and so forth in another minute. But I wanted to let you know there are still other protections in place. If the landlord participated in the Housing is Key program, I think I did that one. Did I go backwards instead of forwards? No. Okay, I just reiterating that if a landlord participated in the program, submitted their own application, they can't evict or charge late fees for rent payments that were covered by the program. Repeatedly asking for payment of pandemic-related debt while awaiting a final decision by the program may be considered harassment under the Civil Code. And a landlord is not allowed to retaliate against a tenant because they needed to apply for rental assistance. That's part of the law that prevents retaliation against individuals for asserting their rights. Now, now that the pandemic protections went away, we've turned the clock back to January 2019, January 2020. Before the pandemic happened, a new law came into place and was called AB 1482, or the Tenant Protection Act. It has two parts. One is rent caps and the other is eviction protections. Now that the pandemic protections are gone, AB 1482, the Tenant Protection Act, is back in place. So with regard to rent increases, they're capped for most tenants in California. Landlords cannot raise the rent annually more than 5% plus inflation for a maximum of 10% each year. Starting August of 2022 in Santa Clara County, that cap is 10% because our inflation was so high last year that the inflation rate plus 5% exceeded 10%. And so that maximum cap of 10% is in place for pretty much all the jurisdictions in the Bay Area, but especially Santa Clara County, I know that is true. So regarding just cause protections, the Tenant Protection Act says a landlord has to have a good reason for an eviction. They can't evict for no reason. So these are the good reasons that they're allowed to use. If you're a landlord, you're allowed to evict tenants. If you plan to move in, you'll have to be able to establish that. if you're challenged in court. Also, if a substantial rehabilitation or remodel is going to happen, again, need to be able to show that is happening. Or if you intend to demolish the unit or withdraw it from the rental market altogether. If a tenant breaks their lease for any reason, like if there's no pets allowed or noise at certain hours or no smoking or any of the rules and regulations that are in the lease, they're allowed to be, tenants are allowed to be evicted by breaking the lease. And that includes non-payment of rent. So for that period, now for non-payment, that the pandemic regulations went away, landlords can evict for non-payment. Also, the owner, if the owner's complying with any court order, government order, any local ordinances that are forcing the tenants to leave or requiring that the landlord have tenants vacate a building, then that's permissible under the law. So, for example, if there's substantial code violations that can't be remedied or need to be remedied without a tenant in place, that would be allowed. As I said, there are some exceptions. It covers most properties that tenants live in, but not all of them. So I want to let you know which ones are the exceptions. And in the case of exceptions, the landlord is supposed to provide notice to a tenant that they are exempt, that the unit is exempt from AB 1482 before they can take any action. So, in fact, any lease renewals that are happening, if the landlord has not informed tenants as of yet that they are exempt from the Tenant Protection Act, there is language that needs to be included with that lease. So the exceptions are single-family homes, unless they're owned or controlled by a corporation. It's not always easy for a tenant to know that, but if you have a private landlord, just a person that owns some properties, then that's an exemption. If you are in a single-family home that's owned by an investment company or a corporation, then that unit is covered by the Tenant Protection Act, and they have to have just cause to evict, and they cannot raise the rent more than 10%. So it's important for tenants to understand the difference. Also exempt are any units that are under a local rent control ordinance that's more protective, in other words, more strict than the Tenant Protection Act. So that's bad news for landlords, good news for tenants if they're in a unit that is in a jurisdiction that has their own rent control ordinance that's stricter. And that might be San Jose. Some units would be covered by a stricter rent control ordinance in San Jose. Units that are less than 15 years old are not included, and those tenants are also supposed to get a notice that those are exempt. Once a building turns 15 years old, then they are covered under the Tenant Protection Act. That was done because the politicians were worried about there being a chill on construction of new housing if they were putting rent caps on newer buildings. So that happened. Mobile homes are not covered by AB 1482. They're often covered because they are covered under other legislation and ordinances. Duplexes are complicated, even more complicated than single family homes. Duplexes, the owner has to have been living there when the tenant moved in, and the owner has to still be living there for it to be covered under 1482. And the other one that is exempt is any affordable housing that's subject to deed restrictions, regulatory agreements, other agreements with the government agency, because they have their own set of rules, and dormitories are not included. So I mentioned that where there's stronger protections in local ordinances, that they take precedence over the state AB 1482. San Jose apartment rent ordinance is one of those. And they have ARO regulations, which can be found on their website. And they have a San Jose tenant protection ordinance that's also has an impact on which units are covered. I'm not clear on what those would be, but I can refer people to sources that can provide that information. Mountain View has a Community Stabilization and Fair Rent Act, and those regulations are also online. And there are limited protections in Palo Alto, Los Gatos, and Campbell. So it's important to check with your local jurisdiction to find out, especially for landlords who are trying to figure out whether they're allowed to evict or raise rent in any way that might be different from the state ordinance. Excuse me for just a second. Sorry about that, got a tickle in my throat. So, as I mentioned earlier, if a tenant gets an eviction notice or an unlawful detainer summons, they need to act fast. With the unlawful detainer summons, you have to file papers with the court within 5 days. And it's important to seek legal assistance with that to make sure that you're answering the summons in a way that will be helpful for you in court. And you can call Project Sentinel if you have an outstanding application or appeal with Housing is Key, the state COVID-19 rent relief program, so that we can try to get that expedited to help you if that's the basis for your eviction. I noticed a lot of landlords who are submitting requests for summons, UD summonses, are avoiding that because it looks like more of them are just for rent due since the end of March. As mentioned, the Santa Clara County Superior Court has a self-help center in person, Mondays through Fridays, 8:30 to 1:30, Monday through Thursday. Friday they close at noon. And you can also access remote assistance Monday, Tuesday, and Thursday, 8:30 to 1:30, or go to the website www.scscourt.org and click Contact the Self-Help Center, and you can submit questions there. There's an online step-by-step guide for California state courts at courts.ca.gov/self-help-eviction.htm. So those evictions are handled in small claims court, and there's, I think I mentioned the small claims advisor. There's an advisor available by telephone Tuesdays from 2 to 4 p.m. and live chat on Tuesdays from 2 to 4 p.m. or email the small claims advisor. And again, all that information is on the court website. I also encourage people to contact the Law Foundation for pro bono assistance if you're being sued for COVID-19 rental debt in small claims court. And this is more about being sued in court for rent. So then at the downtown courthouse, there's a weekly eviction prevention clinic for both tenants and landlords that's open Wednesdays 10 a.m. to 12:45 on North First Street. So it's specifically for tenants and landlords who are involved in eviction court action, non-lawful detainer action, if you have a court case number, you can show up, get connected to resources, get legal counseling, mediation services to help resolve your eviction issue and avoid going to court. So that's an alternative, is to seek mediation. And you can do that by going to the weekly prevention clinic in San Jose, or you can call our program. We administer that mediation program for the court. If you have a case number, call us at 408-414-5358. The mediator can help both sides negotiate a settlement. And by settling, the parties can reach an agreement that provides a fast and flexible end to the dispute. Our mediators are trained, experienced, neutral, and confidential, and all services are free of charge. One of the nice things about the court program is that there is some financial assistance available, especially for San Jose tenants who are really struggling. The most vulnerable can get some financial assistance to help cover that unpaid rent that the landlord is evicting them for. So landlords, keep that in mind, that there might be assistance available for your tenant if you go through the mediation program or go to the self-help clinic at the courthouse. That way, rather than evicting someone and not getting any money, you might be able to get some help for the tenant and give them a little more time. So that's the, oh, I thought I had one more slide. Where did that go? I guess it didn't get saved. I wanted to add a piece about a change in regulations regarding code enforcement that happened July 1st, where cities they used to just really focus on serious code infractions that were going to cause, like, were fire hazards and things like that. They had to be very serious. Under the new state law, cities are responsible for enforcing habitability code under the health and safety code, I should say, habitability issues that fall under health and safety. So tenants can contact their city code enforcement under housing or building inspection and request an inspection. It is prohibited under law for landlords to retaliate by raising the rent or evicting a tenant after they've requested an inspection. However, I am seeing that landlords are giving their tenants notice to vacate or telling them they need to move out. And I've talked to a couple of lawyers about it. It's hard to defend that in court if you're a tenant, because a landlord can cite some other reason saying that you broke the lease by some infraction, and that's the reason that they're evicting you, not retaliation. It's hard to prove retaliation. If you have records of attempts to get problems remedied, repairs done, and you have copies of the information about the inspection, a copy of the report, and so forth, be sure to keep those and bring them to court with you if, in fact, you do get an eviction notice that you believe is based on retaliation, so that you have something to show the judge to help you defend yourself. So that is the piece I wanted to add, and I had made a slide about that and it doesn't show up in my presentation, so I apologize. And now I'm happy to take questions. I see 3 questions in the
Thank
Q&A.
you. Thank you so much, Allysson. Thank you for the information. Yes, let's move to Q&A, and I will stop recording. For your information, I will be sharing the link to the recording after the program. Let me
Great.
stop recording.
Thanks. So I'm looking at